Hello, everybody. Hello, Ava. How you doing, baby girl? Time for her treats. So, hopefully, the internet issue is resolved. I was absolutely appalled when I went to make 3 crew minis from the last week, and I couldn't make any without having to supplement the video with the original, and which took out all of your guys' great commentary, and that bothered me a lot. So I called Spectrum. Sorry if I missed your mouth. I called Spectrum and I told them, hey, Google shows that you guys have fiber optics here. Is it launched yet? And the lady was like, no, we haven't launched it in your area. And she's like, well, have you had a technician out? I'm like, 3 times. I'm like, this is a recurring, continuing problem. And I'm a streamer. And she's like, well, we can send another technician out. I'm like, it's not going to do any good because I've got the 600 megabyte plan, but of that plan, my upload is only 20. That's right, guys. The technician told me there's absolutely no fix to the issue without increasing my package and paying $20 more a month for 10 more. That's it. And so he told me to go with fiber optic back a couple months ago and replace my equipment, and I thought, okay, I'll give it a shot, right? It worked for a little while. And I don't know what happened. I really don't. But the last, I don't know, week or two, the bandwidth has just been going out. I don't know if it's the storms, the cold, the weather, the what. So when I told the lady, I have the 600 megabyte plan already, and I've had 3 technicians. The problem is not the speed of the service. And so she goes, oh, I don't know why you don't have the gigabyte package. It's $30 less than you're already paying. What now? Excuse me? So I went from the 600 megabyte plan for $130 a month to a gigabyte plan for $100 a month. I don't know if that was like a retention plan, and like they're not supposed to use it unless somebody is threatening to leave or asking about a different service or whatever. But yeah, it got switched. So I don't know what the upload speed is. I didn't run a speed test, but I'm really hoping that this resolves the issue, at least for until I can get fiber optics, because I kind of need my service to work. It's the whole point of having it. I understand the download speed's phenomenal. It works great for that. But I already am in a position where the time that I stream is the time they do maintenance. So I periodically just get randomly shut off And there's nothing I can do about it because I'm outside of the norm for business hours, and I get that, and I'm not fighting that part because they got to do their maintenance. And of course, they're going to do it when the fewest people are on. So I'll tell you what, man, I had that Karen inside of me just bubbling up, and I was like tamping her down. I'm like, no, no, don't you dare. But I remember during the video with the entitled lady that ran over those cones, Charlie said the video quality is terrible, and I thought he was referring to the officer's dash cam until I went to make the replay crew mini video. And of course, I had completely deleted the draft of that video because I ended up not streaming the entire thing that I had edited. And so I went in and I just cut what I had already streamed and I added a little bit more, and then I re-exported it. So the first part of that video was gone. I had to 100% remake that video in order to do the replay crew mini on it. I wasn't happy about that. But he was right. The video quality was so terrible. Like when I saw the text, the words, they were illegible. I'm like, this is what people are watching. I can't post it to Spotify when it looks like that. I can't make replay crew mini videos. And then the hilarious episode with Earl. Sorry, I'm gonna turn this down. The hilarious situation with Earl and Billy. What was it? Not last night, but the night before. Earl was so pixelated, which made me sad because he was so funny. Oh, that boy was hilarious. And then I watched the security cam this morning, and around 2:30 in the morning, Earl had gotten up and he patrolled the bed and stuck his head out the window, or the curtains, and did this check of the room, and then crawled up on my belly and went back to sleep. He's protecting me through the night. It's the cutest thing. And Billy had crawled up and laid on my arm, and I was holding him like a baby. It was so cute. Hello, Jerry Matthew Boyd. Hello, C-Rex, honey. I love you to the moon and back. Hello, Nana Laura. That is so great. I am so happy to hear that. There's nothing like spending time with your family. And you've got to enjoy it while you can. They grow up so fast. Everybody says that. But you don't get that time back. Hello, Buzzy Pug, my sweet sis. How you doing? Hello, Wolf Lord Lover. I actually, when I edited, I thought of you, and I got cases from your favorite judge, Mogan. I would have streamed them last night, if I could have. And then I saw that Lone Wolf Sol actually did one of the cases that I did. So if you guys have seen it, you've seen it. I'm sorry. There's more after it. But and I'm not copying him. I just couldn't stream last night. Hello, Charlie. Barbecue. That sounds good. I was thinking about making a burger, and then I got lazy, and I ate an apple instead. That was my dinner. I didn't have to cook it. I had grapes for lunch. Manuel, it's so good to see you. Mortimer Duke made a fart joke in your honor. Not last night, but the night before. Hello, Wire Mother. See here. I wonder where Army Brat's been. I'm wearing his favorite color tonight, and he's not even here to see it. Hello, Eileen and Carlin. Good to see you, love. Oh, I'm knocking down the house, or the coffee at least. Oh, they were just so funny. You'll have to go back and watch it. Like, I can't even describe it. Earl was like sitting in front of the cage, like facing in the cage, eating the air. I don't even know what he was doing. He would lean up and he'd go like this, and then you would just see him. He just kept doing it. And then Billy does what he does. He was cuddling the treat box because he was mad I wasn't giving him treats. And so he was literally hugging the treat box. And then at one point, he decided to come flop on the desk and lay over my arm with just my hand sticking out to use the mouse, which he does all the time while I'm trying to edit. He's laying over here on the bed tonight, or not bed, but the little pad that I have set there for them. Yeah. So I'm happy there. I have an Alienware Aurora R16. It's got a pretty darn good Ethernet card. Hello, Spider-Man. Hello, Sir Philip. Good to see you, honey. I think. Oh, hello, Auntie M, honey. I'm so glad you're here. Oh, that reminds me. I need to add the Spotify link to the link tree. I put it in the description of the channel, and I added it to the description that I put on all the videos. But I think I should probably put Spotify in the link tree. It's not really being watched. So, but I'm still, like, other than the last few days because of the internet issues, I'm still gonna be uploading to it, even though it's not viewed yet. Hopefully someday. Maybe it'll start picking up traction at some point. I mean, I'm getting like a whole whopping 4 people on X. I know. You should see the short where he's licking the toaster. Oh my gosh. Oh, he's so funny. Golly, let me see if I can find that really super quickly. There was one day where I caught him actually licking the toaster, and I'm like, how long has this been going on? Yeah. I mean, you see something like that, and you start having questions. I'll try to make this quick. I'm trying to find him. I mean, I haven't been able to make shorts for a while because YouTube has compatibility issue with my phone. Okay, I found it. View on YouTube. Put it back to the beginning. Share screen. Here we go. Stop licking the toaster. It's plugged in. Why you gotta be so weird? Earl, stop it. Stop licking the toaster. Hold on. I gotta get back to you guys. There we go. They sure do. Especially Billy. He's the hardest one to say no to because he's very persistent. I had a cat that did that once. It would sit there and lick Walmart bags. Drove us nuts because we used Walmart bags in the little trash cans. And the cat would like grab onto it and pull the bag out and then just start like licking the plastic. It was weird. I guess, I don't know, a textural thing. That sums Earl up. I'll have to watch the security cam video again and see the one where he's patrolling and then climbs up on me and Billy's being hugged, and I have to watch it again to make sure, like, you know, I'm fully covered and and make sure like no part of my house that I don't want people to see is visible. Nope, nope, nope. Ava would do that, but now that that's Bandit's room, I keep the lid shut all the time. And the toilet in the basement doesn't even have water in it. Because it's just not used. So I can't believe you did that. We watched it. Hello, Squishy. I think I got everybody. Thank you guys all for being here. It's early, but I wanted to get on and share the videos that I couldn't, and and then maybe I'll be able to make Replay Crew minis again. Wouldn't that be amazing? Oh my gosh. Oh. Yeah. Like there isn't enough embarrassing things out there with me. I mean, I have no problem being the butt of a joke. Clearly. I mean, I made a short of when I imitated a monkey. I made a short when that guy was doing the mating call on the body cam and I imitated the bird. Yes, I am definitely the victim of being Ava's butt joke. Oh, that was such a bad night. For, smells and all. Jerry, you're naughty. You always pray that they're not. Exactly my point. Oh, guys, I'm so happy to be here. Is the video quality okay? I mean, that's the biggest question. Because the other night, even the studio was super pixelated and awful looking. So you can blame Squishy. He started it. Oh, good. Yay. Oh, goody, goody, goody. Hopefully it's fixed. It's because I need it to be. All right, good. Yay. All right, now if the video quality gets really crappy, let me know. Unfortunately, I can't do anything about it but switch companies completely. And I don't know if there are any in this area that offer fiber optic. So I am just going to have to figure it out. Maybe they've got a plan higher than the gig plan. I don't know. Or maybe I can get onto a business account because technically this is my business. When C-Rex texted me earlier, she said, "I love you the mostest," and I said, "I love you to the moon and back, and I'll even bring back one of those little green men to prove it." So maybe you're seeing the Mars me or the moon me. Well, dang it. We'll figure it out. Oh, that's terrible. There was a place that I was working, and it was right outside. It was in the Walmart parking lot, basically. The edge of Walmart parking lot, there was a strip mall. And the business I was working was right in that little strip mall. Like, you walk outside the door and look to your right, and there was Walmart. Um, you walk, I don't know what, 30, 40 feet, and you're on their physical property. I mean, it was close. Walmart had the whatever the high speed was at the time. We weren't eligible for it. They wanted my boss to run over $5,000 worth of their cable line to provide the internet service to that little strip mall. What now? Like, you seriously want us to pay to be able to allow us to pay you monthly? Like, that doesn't seem fair. That's Spectrum. That's Spectrum for you. But at least, okay, fiber optics, from what I understand, if I were to have that, my upload and download would be equal. So I don't know about that. I don't know about that. Elon's pretty determined to get to Mars. It's kind of like his life goal. And he's a determined individual, and he's got a lot of money, so it might not happen in our lifetime. I don't know. But I'm sure it will happen. There's so many people that believe that it already has happened because of that movie. What was it? Was it Interstellar? Was that the movie? I mean, you guys know I'm or maybe it was just called Mars. I think it was Mars. Interstellar was the guy with the bookcase. Yeah. People thought that was real. Like, that was the guy's real story. It wasn't. It was a movie. But I guess that's the sign of a good movie. If you can make people think that, that that's reality. They don't have jurisdiction there. Not gonna lie. I was kind of hoping that for that, that other one that went up. What was that called? Blue something. Blue Origin or whatever. It was all those celebrities. Yeah. They came back. And then turned out it was just a publicity stunt for whatever that singer's name is. No, he's not. He is not. I think the bigger problem is the atmospheric conditions more than the distance. I mean, you run into one issue at all that you're not prepared for, you're screwed. Nobody could get you resources, or they can't do a drive-by fueling or anything like that. I definitely would not want to be an astronaut. It's not a life goal for me. That's cute. I like that. That's cute. I don't know what you mean by that. I'm sorry. I'm really sorry. There you go. Another reason why I couldn't go there. I had to DoorDash a battery jumpstart pack the night of the snowstorm because I had to go to Baraboo the next day. By the way, Baraboo does not have DoorDash. I was shocked that we have it here in Toma, and it's huge here. Baraboo doesn't have it at all. And they did have a couple like independent delivery driver type services that were trying to be startup companies. They've all gone under. It blew my mind because Baraboo's actually pretty big, and it's a huge fast food community. Like several of the fast food restaurants in Baraboo are the top performing restaurants of their brand in the state. I know when I was a shift lead at Hardee's, we were the number one all-star in the state. And there was the owner ended up in some financial troubles with his other stores, and he had used Baraboo as collateral, and he tried negotiating with the bank and being like, I'll give you 5 Milwaukee stores if you let me keep Baraboo open. And the bank's like, nope, we want your property. And they took it. So learning, that's the biggest part. Stretching our limits and seeing what we're capable of. Oh my gosh. I drove past the circus when I was in Baraboo, and it has changed so much from when I was a child. So much. Everything has. It's crazy. I don't like it. I don't like change. Oh no. Squishy had sent me a video of where Judge Middleton lives and all the flooding that's going on there in Michigan. That's terrible. I hope you're safe. Okay, good. Do both. Send all of the rich people to Mars. That'll fix Earth. No, I'm just kidding. I'm kidding. That's a joke. They do seem to be the most problematic attitudinal wise. But we need them. All right, guys, let's put a video on and see if the clarity is any better now. What is up with this? I think I need to, I think I need to move. I think I'm running out of internal storage and I need to move everything to the external drives again. It's been about a month. There's at least a terabyte there. Here we go. Finally. It's just taking forever to load.
We are ready to start recording. We are live on the record in cause number 23-09-13702. This is a motion to confirm support arrearage. This was filed by the Attorney General's Office November 27th of 2024. The parties are all present before the court today on Zoom. This is a remote proceeding, and I am sitting outside of Montgomery County, Texas, pursuant to the Texas Family Code, Section 201.1045. And I find nobody has objected to proceeding this way.
Objection, Judge.
Okay, one moment, sir. Ms. Baskins, can you please state your full name for the record?
Yes, ma'am. It's Adrienne Baskins.
Okay. And sir, can you state your full name for the record, please?
Yeah, I'm Zahir Dean, the living man.
Okay. And Mr. Dean and Ms. Baskins, can you both please raise your right hands to be sworn in? Do you each solemnly swear that any testimony that you'll give today will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
Okay. Is everyone ready to proceed today?
Yes, Judge Julie Kahn for the Office of the Attorney General.
Before we begin, a few
I'm sorry.
housekeeping items. The first is I am an associate judge, and you do have the right to a de novo hearing before the referring court regarding decisions I make. Also, nobody should be recording this. There should be no audio recording, no video recording, no photographing, no broadcasting of this or any other court proceeding. And that includes you all here on Zoom and anyone who may be watching on YouTube. Also, we generally take testimony in court. It's important one person speak at a time. We should use civil tones with one another. Once we start taking testimony, one of you will be asked questions at a time by the Assistant Attorney General. If you're not the person being asked questions, if you have a legal objection, please interrupt, but otherwise, please don't interrupt them or answer for them. You'll both be given a chance to be asked questions, and at the end, you'll both be given a chance to speak as well, since you don't have counsel representing you. And then lastly, just know I'm not with the Attorney General's office. And so things you've discussed with them in the back or spoken to them about, they're not allowed to tell me about that, and they don't. So you're likely to be asked questions that you've answered already today or other days. All I know about your case is the pleading on file, and then I believe you were before me once before. So I vaguely remember that, but do keep in mind I have multiple hearings practically every day. And so not all details stick in my head from day to day. That being said, Mr. Dean, you wanted to say something?
Yes, thank you, Judge. Judge, I'd like to say I'm here on special appearance. But first, we were here last time and I was really sick and I wasn't able to speak. So I appreciate you giving me the time to recover and come back here today.
Better.
So I'm here on special appearance, Judge, and I am looking for a dismissal of this case due to due process violations. I was not given proper notice. And in the notice, I wasn't given a clear statement of the proposed actions. I wasn't given the specific reasons or grounds for the proposed actions, including a description of the facts and evidence upon which the actions based off of today. I wasn't given sufficient detail so I can understand what is at stake and what I need to contest or respond to. And I wasn't given information about how to access the procedures for responding or contesting the actions, including contact details. So because of this, I'm requesting a dismissal of the case, Your Honor.
And just for clarification, sir, have you filed anything requesting this relief?
No, because I don't know what's going on.
Okay.
I don't have any information. Was not noticed given the proper notice. And because of that, there's no way for me to proceed.
Yeah, I offered to email them to him this morning. He was served back on June 10th by side posting and so on his door. He was served.
Objection. Is there evidence to prove that, Your Honor?
So I'm looking for the service return right now.
I have it pulled up. I can share the screen if I need to.
Okay. You might as well, so he can see it. I have it pulled up as well right now, though. It's a different device.
So it just says on June 10th, 2025, it was posting the citation to the front main entry door per Texas Rule 106.
And I do take judicial notice of that executed service return.
Oops. Okay, so that was just the preset, but this is also the motion to confirm and the motion for substituted service was all served on him.
Oh yeah, it's multiple, but yeah, the 3 pages in that service return.
If I've got an objection on that, Your Honor, it says it's been posted on my front door.
At the front main entry door is what it says.
Yeah.
Yes.
I did not receive that, Your Honor.
Okay.
I've got an objection to that.
And hold on one moment.
I believe he also signed the reset last time we were here.
Yes, I do believe you've made an appearance in the case. So, sir, you're claiming right now that you don't have a copy of the pleading. Is that true?
So I've got an objection to that as well, Judge. So when we were here before, I did have a means to communicate with the clerk prior. However, during the Zoom when we were speaking to you, I did not have a means to communicate in terms of chat for me to object to that. But now I'm able to speak. I agree on a reset to come back to figure out what's going on here, but my objection still is for due process not having the sufficient amount of information.
Judge, I apologize.
That's okay. Please talk.
I'm willing to take a short reset. I can email him the pleadings. I've offered to do that before, and if he needs a chance to look them over.
Yeah, and I've got an objection to that, Your Honor. Due to the due process violation, I'm requesting a dismissal.
Okay, sir, this is not a well, I'm finding it's not a due process violation. You are here, people are allowed to make appearances before the court. You've made an appearance before the court multiple times now. I'm not dismissing this lawsuit. It's a matter of making sure you do have proper notice to proceed, though, and fairness. And so I do want you to receive a copy of the pleading so we can proceed. I do believe last time, Ms. Khan, because I thought this case involved a modification and confirmation. I believe last time Ms. Khan, correct me if I'm wrong, I think it was this case, corrected me and said this was just a confirmation of arrears. We're just confirming arrears in this case.
That is correct, Judge.
Doesn't make it any less important. There may be all sorts, there might be, I don't know, there could be possession credit issues, there could be direct payment issues, could be all sorts of things. And I want you to have your day in court in fairness. But I am denying the request to dismiss this action. I don't find it's been a due process violation. Have you provided Ms. Khan information, a way to send you a copy of the pleading so you can review it?
Your Honor, so I've got an objection on the appearance as well. I'm not here, or nor have I ever been here on general appearance. I've always represented myself under special appearance.
I don't know what that means, sir. Are you not a person?
I am the living man.
What does that mean?
I am a man.
You are a man, I'm a woman, but I'm here. You're here.
I'm here as a living man representing myself.
Under what legal basis are you doing that?
Under constitutional law.
I'm finding you're here and you're making an appearance, sir. I don't know what law you're referring to. If you'd like to cite a specific statute or a specific part of the Constitution, I am open to reading it. But my understanding of the law is you're here, and there's no legal representation of yourself in that form. So I would like you to receive a copy of the pleading. I'd like you to review it. If you need additional time, I'm even open to resetting this to the December 11th date, although I'd rather not. But in fairness to you, if that needs to happen, I will give you a little more time.
That would need to happen, Your Honor.
Okay, but I want you to receive a copy of this pleading so we don't have the same discussion next time.
I've
does-
sent it. Can you check your email and make sure you
Oh.
have received it?
I'm checking now.
Okay, thank you.
I received it. I don't know if you heard me, but I'm sorry. I said I received it.
Okay, thank you. So you did receive it?
I
Just to
did.
confirm.
I did via email.
Okay, do you want to review it now or do you want some time to review it before we proceed?
It's a pretty long document. Yes, very long document. I'll definitely need time to review.
Okay, and just so you know, despite the length of the document, we will be proceeding to final trial on December 11th, 2025. No more resets. I expect everyone to be prepared. I think I told you all this last time, but be ready to proceed next time with I did say this last time, with any witnesses or any documents in electronic form. Be ready to go.
Yes, ma'am.
Okay, so it is reset for December 11th, 2025 at 9 a.m. on Zoom, the same Zoom code information.
All right. I will send out a reset. Just give me about 5-10 minutes and I'll send it to your same email.
Okay.
Mhm. If you want to go back to the breakout rooms and make sure I get the resets to you.
I'm okay with the verbal reset. I'm not going to sign any documentation.
Okay, I'm just letting you know, I'm going to put in Odyssey that you have been noticed of today's setting, and if you do not appear next time, we'll proceed with or without you, sir.
That's fine, Judge.
All right. Well, I guess Ms. Baskins, you're free to go. I will send you the reset. Just check your email in about 5-10 minutes for me if you can.
Thank you.
And we can stop the recording.
All right.
We are live on the record in cause number 23-09-13702. And this is a motion to confirm support arrearage. This was filed by the Attorney General's Office November 27th of 2024. The parties are all present on Zoom today, and this is a remote proceeding. I am sitting outside of Montgomery County pursuant to the Family Code Section 201.1045. And I find nobody has objected to proceeding this way. Mr. Dean, can you state your full name for the record, please?
Yeah, I'm the man, Zahir of the Dean family, and at this moment, I would like to say that I'm here on special appearance, and I don't consent to any agreements, or I don't give up any, and I don't waive any of my rights.
Right now, I'm just swearing you in, and we'll get to your special appearance in a moment. I understand you want a hearing and don't agree to anything. Ms. Baskins, can you state your full name for the record, please?
Yes, it's Adrienne Baskins.
Okay. Can you both please raise your right hands to be sworn in? Okay. Mr. Dean, is your hand up?
Oh, yeah, sorry.
Okay, thank you. Do you each solemnly swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can both lower your hands. And counsel for the Attorney General's office?
Julie Kahn for the Office of the Attorney General.
Okay. Mr. Dean, did you file anything about a special appearance?
I did.
You did?
I did.
Okay. Would you know about when you filed it?
I filed it yesterday, Judge.
Oh. Okay. It has not made it to the court file. As Ms. Foote, do you see it? Is it in the documents?
No, ma'am, I don't, but I will check e-file and see if it's in there by any
Okay.
chance.
Did you electronically file it, sir, or did you walk it?
I did. I e-filed it, and I've got an, I can get you the envelope number.
You have emailed it to us. Is it the affidavit of truth?
Yes, I emailed it to you as well. In addition, I e-filed. I've got an envelope number if that would help. Would the clerk like the envelope number or?
I don't need it. I can check by the case number. I'm checking right now. There is a demand letter as the description. It has not been accepted. I'll get it accepted right now.
Thank you.
And Judge, you
It's been
mentioned-
accepted. It should come up in the system in just a few minutes.
And Judge, you mentioned you're coming outside of Montgomery County. Specifically, where are you coming out of?
I am in Harris County, and I'm doing this pursuant to the Family Code 201.1045.
Thank you.
My clerk is in Montgomery County today.
Okay, thank you.
Thank you.
Judge, it is in the file now.
Showing, but it doesn't let me click on it.
Judge, you might need to go out of the case, then come
Yeah,
back
I
in.
found it in the documents tab, so I think I
Okay.
can pull it up that way.
Okay, thank you.
I'm going to take a moment to read this. Okay. Mr. Dean, why don't you proceed on your pleading? Though I'm going to say I don't believe this is timely. But you can explain to me why it is.
Okay. So Judge, so all of the times that I've came into court, I've always mentioned that I'm under special appearance, and the sole.
Can you explain what that means to you?
Yeah, well, I actually had the definition from Black's Law Dictionary instead
Okay.
of giving you my interpretation of it. All right. So under Black's Law Dictionary, it says special appearance is when a defendant appears in court solely to contest the court's power over them without submitting to it, often
Okay.
called limited appearance. General appearance is basically when someone comes into court accepting the jurisdiction and so forth.
Okay, so can you explain why the court does not have jurisdiction over you?
Yeah, so because civil procedure was not followed under Rule 107, that identifies that the court doesn't have jurisdiction to proceed with a judgment because the civil procedures was violated.
Would you like to flesh that out more, sir, or do you want to leave it at that?
And you mean in terms of?
What you're saying?
So basically
How was
what
it
I'm
violated?
saying, yeah. So there's not a return to service that was filed, and specifically in the affidavit, I've listed out the Rule 107 for return of service. That's the requirements for it, and that was not followed. Because that was not.
Can you specify what part of the return of service was not followed?
How about you read the judge more of the Black's Law Dictionary? I bet that's super helpful.
Yes.
There is a return of service on file. So which of those many rules you listed out did not happen? Or should we go through them one by one?
So there's not a return to service on file, Your Honor.
There's an executed citation, a constable return of service and citation. It was filed with the court, I believe, June 16th of 2025.
Was that under e-file?
It's in the court file. I'm not sure how it got here.
Is Mr. Dean done? Is it?
Yeah, Mr. Dean, are you looking at something, or is there more you'd like
No,
to say?
I'm sorry,
about
Judge.
what? Okay,
I'm
I
sorry,
thought you were
Judge.
looking at something. I wanted to give you time to look for what you needed to prepare.
Oh, okay. I'm sorry. I thought I was waiting on you. I thought you were doing something to where.
No, I was just waiting to see.
Okay, so the document you're looking at, Judge, you're saying it's on the court files.
In the
I'm
court file, yes.
in the court file. So I'm not seeing that under e-file. And when I looked up that information, there
Are
was
you in research? What system are you using to look up information? Because it's possible it's just not there because it's not the official court file,
okay.
but I don't know what you're looking at.
The guy needs a Ricola. I had to cut out so many of his. It drove me crazy. Ricola.
Ms. Khan, are you able to see it in your accesses?
I can share the screen, Judge, if you would like to show where he was served. I think we did this last time too, though, at the last hearing. And we acknowledged that it was service by posting on the door. He said he didn't get a copy of it. And so I
Then you
emailed
sent him.
and he acknowledged on the record that he had received it. And so we've already covered all of this.
Yes, Judge, and I had an objection to that, still identifying that's not return of service under civil procedure.
Is there anything else you'd like to say, Mr. Dean?
Ms. Khan was saying that she was going to share that document with us.
See, I mean, I feel like we've already covered all of this, but
We haven't. The last time we were here, we did not see that document.
You may pull it up, Ms. Khan, so he can see it. If it's-
so this is the second page. First page is just the citation, and then this is where he stated where he left it.
It looks so familiar.
So I was speaking to Ms. George, and she is stating that this is part of the citation. It's not the return to service.
I'm sorry, who's Miss George?
She is the child support case representative, Kanisha George. So this document is the actual citation, Your Honor.
According to the child support officer.
Yes, ma'am.
Okay. Ms. Cott, is there anything you'd like to say in response to his allegations?
Judge, he was served by substituted service, and it is duly on file. There was proper motion filed, so following the rules of civil procedure. And also his issue was saying that he had not received a copy of it. He has since received a copy of it, accepted that copy. So at this time, I would state that we should be able to move forward.
And I've got an objection to that, Your Honor. As long as civil procedure is not followed at the very beginning, there's no reason for a judgment because the civil procedures was not followed initially, according to Rule 107.
And Ms. Baskins, is there anything you'd like to say?
My understanding is we're just confirming arrearages today. I'm not sure what the trouble is.
Okay. Can you please stop sharing?
Yes, Judge.
Okay,
Oh, I'm sorry. Oh, yeah, I'm sorry. That's fine. Go ahead.
just so I can see everyone. Was there something else you wanted to say, Mr. Dean?
I'll say anything else if anyone else has anything to say for me to rebuttal, but if no one else has anything to say, I'm fine. I'm good.
I bet if anybody does say anything, his response is going to be objection.
And Ms. Baker,
Judge Baker. Yes.
Oh, Judge Baker, I'm sorry. Apologies. Judge Baker, on this recording here, is it public record? And where can I go to get a copy of the recording?
You would have to request that we send it to you, sir.
Okay, thank
We
you.
don't post it online or in a file for the world to see. It's not public record.
Okay,
And
that's-
only an audio recording. We don't have anyone to transcribe or officially do any of that.
okay, that's good to know. The last time we were on here, someone recorded and posted it online.
Okay. And people, we do we broadcast on YouTube, sir, and people do that. They are not supposed to. As you can see, there's a little screen up that says recording is prohibited. If you know who did it, please do let the court know.
Okay, thank you.
But right now it is on YouTube, but I take all my YouTubes down almost immediately following the hearings.
Okay.
They're not posted for perpetuity online. But if you do know who did it, please let us know. And nobody here should be doing that. Ms. Baskins, you should not be doing it. Mr. Dean, you should not be doing it. No one from the Attorney General's office or the clerk's office should be doing it. And nobody who is watching right now should be doing this.
Okay, I definitely did get some hate
I'm sorry about that.
harassment items with it.
Yeah, and I don't like it being up there either because the same applies to all of us up here. We all get that, including me. So
Yeah.
I can't imagine why you would get hate. I mean, you're only a year behind on back child support, trying to delay the hearing, trying to get out of supporting your children, using all these BS sob sit tactics. I don't know why anybody would toss any hate towards your way. I definitely do not support doxing. I don't want any of my viewers to contact him and throw shade his way. But I'm not surprised if people do.
but we do have open courts in Texas. And if we were live in the courtroom, anyone could come and watch it as well. So this is how the people who make the decisions have deemed we comply with that provision. Okay, I'm sorry. Let me go back to what I was thinking. Okay, I am denying the special appearance. I'm finding the return of service is on file with the court and on its face valid. Also finding a motion to quash could have been filed if there was a claim of defective service. And under Rule 122 of the Rules of Civil Procedure, if it was quashed, you would be deemed served by 10 a.m. the Monday next after the expiration of 20 days, the regular answer time. And it would have, at that point, you'd be in the lawsuit. So I'm not finding that there's anything that's been pled or argued that would show that the court does not have jurisdiction over you, sir. There's a prior order in this case. So I do find jurisdiction is proper and the return of service on its face is valid. You may proceed, Ms. Khan, with the motion to confirm arrears.
Yes, Your Honor, I would offer the pay records. We have two in this case. There's one from the Harris County cause number and then one from the Montgomery County cause number. If I may share the screen.
You may.
Mr. Dean has been sent copies of these today via email.
Okay, wait, before we share screen, does anyone have any objection? I'm confused as to, since the case was transferred here, I'm confused as to why there's two pay records. But Mr. Dean, what is your legal objection?
I have an objection. I was here under special appearance and I'm prepared to be here on the special appearance. Now that the court is transitioning this to a general appearance, I request time to prepare.
So you were given time last time to prepare?
Under special appearance, Your Honor, and I did.
But that has been denied. This case was filed November 27th. We're already after over a year.
Correct. So you've denied it today under special appearance. Now that you've denied it on a special appearance and it's a new appearance under general appearance, I'm requesting time to prepare on the general appearance.
Ms. Khan, do you have a response to that?
Judge, this case is already over a year old. I have a feeling that it will be dismissed if we don't go forward today.
Your Honor, I've got an objection on Ms. Khan's feelings of being dismissed. It's not evidence.
Ms. Baskins, is there anything you'd like to say?
I mean, this is like our fourth or fifth time to reset this. I feel like the matter at hand, simply confirming arrearages, is we're not arguing about anything else. I feel like it's pretty straightforward.
I'm going to deny your request, sir, and we're going to proceed today. We're going to begin, and just a few housekeeping items. I am an associate judge. You do have the right to a de novo hearing before the referring court regarding decisions I make. Everyone should be speaking in civil tones. which you are doing, so thank you for that. And we generally take testimony, so one of you will be asked questions at a time by the AG. Since you're both representing yourselves, you'll both be given a chance to speak as well at the end. And then just be aware, aside from things that have been said before me, I don't know what you all have discussed in the back or on calls with the AG's office, so just be aware I'm not with them. So you might be asked questions or things that you've discussed previously. Just be aware that that's how I do get the information. And so does anyone have any legal objection?
I've got an objection, Your Honor.
Okay, what is your objection? Can I finish what I'm asking that what you're objecting to?
Yes.
My question was, does anyone have any legal objection to the pay record or the pay records that Ms. Khan is attempting to admit?
I've got an objection to it, Your Honor.
But what is your legal objection?
So Ms. Khan is a third party in this case. The case is between the state of Texas and myself, and I'm wanting to know, Ms. Khan is a third party submitting evidence. Is the state of Texas submitting any evidence as well?
I'm sorry, is the state of Texas doing what?
Submitting evidence. It's two separate entities, Your Honor. Ms. Khan is with the Attorney General office, and according to the communications that they've been sending, they are a third party. And the case here today is between myself and the state of Texas. I'm wanting to know, is the state of Texas providing any evidence, or is Ms. Khan providing the evidence?
I don't think you understand. Ms. Khan represents the state of Texas. The Attorney General's office is part of the state of Texas. And I'm overruling your legal objection. Do you have any legal objection to the documents?
So no, but I do have another objection, Your Honor.
Okay, what is your objection?
So the second objection is that if we're going to move further with the case, I'm requesting a trial by jury.
Okay, that has not been timely requested, nor are you guaranteed one in this case. So I'm denying that request.
I've got an objection to that, Your Honor. Since as of today, we're moving forward with general appearance. I'm requesting a trial by jury because this is a new appearance. And I'd like to get time to prepare for a trial by jury.
It's a new appearance and not so special.
Ms. Khan, do you have any response to that?
The judge in Texas, a jury doesn't determine issues related to child support.
Yeah,
Yeah.
what is the jury issue? I'm not sure a jury would hear a confirmation of arrears.
Sir, I'm just objecting to exercise my right to trial by jury.
I would argue that child support is a legal issue and reserved for the court and would not be an issue for the jury.
I don't object to that, Your Honor. Is there evidence to that statement? Is there a rule, a law to that statement? Or is it just Ms. Khan's opinion?
It's Judge's Family Code Section 105.002 lists the issues that may or may not be sent to a jury. And it does say 105.002C2 states that the court may not submit to the jury questions on the issue of support under Chapter 154 child support and several other things, but that's the one.
Yes, thank you. And I'm finding this request not timely either. Based on 105.002, this is not a jury issue, and it is not a timely jury request. Jury requests must be made in writing. This is not in writing either. And so, does anyone have any legal objection to the pay records being admitted into evidence?
Your Honor, I know that you're going to proceed from now on, but for the record, I'd like to state I do have an objection for the rest of the proceedings.
Overruling your objection. Ms. Baskins, do you have any objection to the pay records being admitted?
I do not, Your Honor.
Okay, I'm admitting the pay records into evidence as States Exhibit 1 and 2.
Judge, if I may share the screen, I have. I'm sorry, lost it now. Did it share? It didn't do
It
it.
is shared.
Is this the
Looks like the Harris
the
County.
2021? Yeah. So Judge, this one shows as of November 30th, child support arrears of 12,353.91. I'll stop. And
Oh,
then
can I look at that closer? So what is are you going to ask questions about this so I get more information?
I can a little, yes, Judge, but I was just going to show the numbers first. So this is
Okay.
as of November 30th, under the Harris County cause number, there's 12,353.91.
Okay.
And then under the Montgomery County pay record, there's child support, medical support, and dental support as of November 30th. Child support is 2,610.62.
Sorry.
Medical
Child support was for what?
$2,610.62. The medical is 1,601.81. And then dental is 159.98. Okay. And at this time, I would call Mr. Dean. Mr. Dean, can you state your name under?
Yes, I am the man Zahir Dean.
And do you understand that y'all had a divorce decree in Harris County? Is that correct?
Yes,
And then it was transferred to Montgomery County, and y'all got a new order and a suit affecting the parent-child relationship that changed the amount of child support. Is that correct?
yes.
For whatever reason, that order didn't combine the arrears from that prior order from county. And so today we're looking to combine both of those together into one number. So instead of 2,610.62 and 12,353.91, we combine it under one cause number, so you don't have two different cases paying into, and it would be 14,964.53. Are you in agreement with that?
I don't know what you're like. I don't know the details of what you just said.
Okay. So do you understand that y'all had two different cases? Y'all had a case in Harris County, the divorce decree, correct?
Right.
And then you came to Montgomery County, you transferred the case, and then you had a new case that changed the child support amount a little bit for the Montgomery County case, correct?
Right.
And you've seen the pay records I've sent to you and I've shared them on the screen. Do you have any dispute that the pay records are correct?
In terms of what I've been paid at work,
In terms of what payments have been made towards this case?
and the information that you've shared with us earlier on the pay records, did you pull that directly from the child support account under the Attorney
Yes.
General? Okay. Yeah, that's the tool that they've used to garnish wages.
Okay, so are the pay records correct so far as you know?
I haven't reviewed it, so if that's the tool that they're using for the pay records, then that's the tool that they're using for the pay records.
Have you made any direct payments to mom, giving her cash instead of paying through the OHUs?
No, I'm court ordered not to. I'm court ordered to directly pay through the Attorney General's tool.
Okay.
Any payment towards mom directly would not be considered a payment.
Judge Oakley would have a field day with this guy. He would wipe the floor with him. It would be glorious to see.
So do you have any reason to dispute the numbers that we're saying that should be combined together into one judgment?
I do have an objection based off of me being here today based off of the initial rulings from my objection.
But you don't have anything to say about the numbers.
No.
I'll pass the witness, Your Honor.
Okay, you may call your next witness.
I call Ms. Baskins. Ms. Baskins, I think you're on mute. Can you state your name?
Adrienne Baskins.
So today I'm just trying to combine the arrears. I want to confirm the child support arrears as of November 30th for $14,964.53, medical support arrears for $1,601.81, and the dental support arrears for $159.98. Are you in agreement with all of that?
Yes, ma'am.
All right, I pass the witness, Your Honor.
The state does not represent either of you, so I'm going to give you both a chance. If there's anything additional you'd like to say that you think I need to hear about the arrears, and what the state is requesting. Actually, Ms. Khan, why don't you do a quick summary, because I think you have one already of what you're asking for, and that way everyone will know exactly what you are asking for if they want to object to it or contest it.
Yes, Judge, we're just asking confirm arrears as of November 30th, 2025. Child support arrears would be the amount of $14,964.53. The state would ask for a payout of $100 a month. Medical support arrears of $1,601.81.
Sorry, can you slow down a little so everyone can follow that? Medical is what?
Medical is $1,601.81, and the state is asking for a payback of $20 a month. And then the dental support arrears of $159.98, and we're asking for a payback of $10 a month towards that.
Okay. So,
Your
now that
Honor,
everyone's heard, would you like to respond to that request?
Yes, Judge. I've got an objection. I saw the Attorney General's data for the actual child support, but I did not see the supporting evidence for the medical, dental, and so forth at this time on how that number came about.
Ms. Khan, would you like to call witnesses on that issue?
I can just answer the question. It's based off of
fine.
the 2024 order that the parties had entered into. I think that
I don't know if it's like I can take judicial notice of that order, including page 20 of 29. Orders Zahir Dean to pay Adrienne Daniel Baskins as child support the amount of $318.80 per month for the cost of health insurance, with that first installment being due and payable on August 1st, 2024, and a like installment being due and payable on or before the first day of each month thereafter. So that's where the cash medical comes from, and the dental support starts on page 21, and there's a paragraph on page 22 that says that Dean is ordered to pay Adrienne Danielle Baskins as child support the amount of $30.95 per month for the cost of dental insurance, and then it continues with that same language. If that helps, I take judicial notice of that 2024 order, and you may continue, Ms. Khan. Since I had it up, I figured I would help you there.
that would, and then it's also reflected on the same pay record that we had already discussed.
So I've got a clarification that needs to be made, Your Honor.
Okay.
So when they say that I needed to pay that, right, is it under the impression that it's going to be pulled under garnishment of my paycheck, or?
I'm gonna stop for a moment and say I am not on the witness stand, but I'll give you just some general information. When child support is due, it is due. I believe there's even a section in here that says it's all due and owing. I usually, if I'm setting child support, have been known to give a speech something like this. You are responsible for making your child support payments. Generally, the AG's office will issue a wage withholding order. If you don't have the AG's office in your case, usually a private lawyer will issue a wage withholding order. But you are ultimately responsible for the payments, not that wage withholding order. And so what I always encourage people to do, is to look at their paychecks, look at what is due, make sure the full amount, especially when modifications happen. Often things don't happen quick enough. I don't know why. It's not always the AG's office's fault. Sometimes it's the employer, but for whatever reason, it doesn't always quickly happen. And so people need to look at paycheck stubs and look at what's coming out and look at what's due and pay anything extra that's not due. Not everyone works for a company where you can withhold. Some people have jobs that they have to make not direct, they have to make payments themselves through the SDU, where that wage withholding order is not effective and they are not relieved of their child support payments. So I'm not sure if that answers your question or not, sir, but ultimately, however the payments get made, they're supposed to go through the state disbursement unit and you're supposed to pay them.
And it looks like we had someone join in, Wendy Cordova. Oh, she just jumped back off.
We're open courts, so people are here for all sorts of things, but they are all participants or with the AG's office. Ms. Baskins, is there anything else additional you think I need to hear?
Not at this time, Judge.
And Ms. Khan, just to clarify, because that was up pretty fast, the amounts that were due under the Harris County order, they stopped once August 1st came around of 2024, I believe it is.
Yes, so
There's no double dipping.
I think it looks like it even, yes. Stop. Last one was April 30th, 2025. Oh, well. Oh, no, I see it. July 1st, 2024 was the last time we billed for that one. And then I believe.
Then this starts up on August 1st of 2024 for the Montgomery.
Yeah.
Okay, so that they.
Yes, the last time we billed him was July 1st, and then it switched to the other one.
Okay, I'm going to confirm the child support arrears based on, actually, what I'm going to do, Ms. Khan, I'm concerned about interest and I'm not sure what will happen. So I'm going to confirm the arrears in the Harris County cause as of July 31st of 2024.
Okay.
Here in Montgomery though, so that you can enter into your system the judgment as of that date. And then the Montgomery numbers will just roll from there. Because I don't want to.
But it's actually higher, which is weird.
Is it because some payments were made since then, or?
Yes, there were payments made since then.
That's
so
why. Okay, so those payments will still accrue and it'll all go down. Correct?
Yeah.
Okay. And so as of, did you understand? So what I'm going to do, sir, I don't want to possibly double dip on interest. I don't think it's a doubling, but I do think mathematically this will be less interest in the long run. I could be wrong. But I think I don't want to compound anything. And so I'm just going to confirm the arrears that were due based solely on the Harris County order that is now transferred to Montgomery and is here in Montgomery as of July 31st of 2024. So that will be the starting of the pay record for Montgomery now is whatever was due under the old order. And then anything new that accumulates or gets applied will get applied all combined now in that order. So anything you've paid to either causes since then should continue to apply, correct, Ms. Khan?
Yes.
Okay.
So
what is the number as of July 31st, 2024 for?
12679.31.
Okay. I'm going to confirm the child support judgment as of July 31st, 2024. There was no Montgomery County obligation at that date, so there's no confusion there. So the judgment against Mr. Dean in the amount of $12,679.31 as of July 31st, 2024. I'm ordering that he pay that back at a rate of $100 per month, beginning January 1st, 2025, with step-ups as child support goes down. So the child support's going, let me get those numbers.
Just go up to 1994. What is it? Child
Well,
support.
there's 2 children. There's a step down.
Oh, yeah, there is.
So the first one is 1893. 4 minus.
It goes to 1731.
So it looks like $478.67 will be the first step up. And then the next one would be $1,993.34 until paid in full. Does that make sense for drafting?
I think so.
Okay. And so the state's going to draft the order based on my ruling today, and they'll be circulating it to y'all through DocuSign to review and sign off on, and then you'll be free to go. But thank you all for coming in, and good luck with everything going forward.
Hey, Judge, what I'd like to do is once she sends it through DocuSign, I like to print it out and actually sign it with my own handwriting.
Should we set this for entry?
We can. And did you want to bring it in person?
Oh, I guess I can just email it back to you.
You have that capability to print and email back today?
I do.
Okay. I guess we don't need an entry date then?
I mean, if he doesn't sign it by today, I'm probably just going to submit
You
it
submit
without.
it? Okay. So you can get that done timely today? Because if it doesn't get returned to the AG's office, she'll just submit it in the way she sends it to you?
Okay.
Okay. Okay. So we're going to stop the recording and let these people in who are waiting, and they're going to have you go back to your breakout rooms where you guys can wait for this, and then you'll be able to print, sir. You'll be able to review it, ma'am, and you'll go from there. So thank you all again, and I'll let them help you.
Thanks,
Okay.
Judge.
Okay.
You know, the one thing about having it on the record like that, he's never, ever going to see another tax return in his life. They will all be garnished. And you're right, though, Jim Tidekey. He probably switches jobs just as soon as the garnishment hits. Jerry said several times that he changes jobs often. So, yeah, the only way that they're going to get payment is forced payment. Whether he's jailed or they take his tax returns or, anything like that. They're going to have a lien on the living man until he ain't alive no more. Hello, Bill Crayer. Welcome.
We will go on the record in the matter 24 CF 156, State of Wisconsin versus Nicholas Morseth. The state appears through District Attorney Kevin Schmidt in person. Mr. Morseth appears in person with counsel Nicholas Davis. We're set here today in this matter for a plea and sentencing. The parties have reached an agreement. Mr. Davis, please recite it for the record.
Your Honor, in case number 24 CF 156, Mr. Morseth is going to plead guilty to count 4, which is a misdemeanor battery. It's my understanding that the other counts would be dismissed. And the reason for that is I believe my client has already paid the entire amount of the restitution. It's my belief that the state is going to be arguing for a withheld sentence and probation with conditions. And it's my belief that as part of our agreement, the state was going to allow the defense to be free to argue. And whatever the court costs and fine are, the defense will be stipulating to that. But I believe that to be the agreement, Your Honor.
All right, dismissing outright or dismissed and read in?
Dismissed but read in is what I always assume.
Okay.
I guess I was, we didn't really knock that down. I guess I assumed because he had paid the restitution, there wouldn't need to be a read-in charge, but I guess it doesn't matter because I think the court can take into consideration even outright dismissed cases. So
It can.
it doesn't, I don't think there's any benefit if whether it's dismissed and read in. So I'll let the court decide what they want to do.
Well, Mr. Morseth, why don't you decide what you want to have done with those other charges? Dismissed and read in means that the court can look at both dismissed and read in, but with dismissed and read in, it means that once they are dismissed and read in, you can never have other charges related to those again or this incident. Dismissed outright means if some other evidence comes down the road in a week or 2 or 3, the district attorney could charge you again with those.
we'll stipulate, I'll advise my client that dismiss and read in is acceptable, Your Honor.
Yes, Mr. Morse?
Yes, Your Honor.
Okay, all right. So that is the agreement that's been reached. I believe we have a witness here or a victim here who would like to make a statement. Ms. Bauer, the victim can come up here. He can state his full name or initials if he wishes.
Richard E. Yeager.
All right, can you please speak into the microphone?
Sure.
And just let me know what you wish for me to know. If you are reading something, please read it slowly and enunciate your words. Okay?
Okay. Is that better?
That's better.
This attack was about a lock on a pole barn. The pole barn is a very large building that we have at my mother-in-law's farm. She gave me approval to put my enclosed trailer in there that had a lot of our housing items in it. And she also gave me the okay to put a lock of my own on there with my key because nobody else needed to go in there, as how she said it. We were living in our motorhome. We had been living in a motorhome for 3 years around the country. We decided not to stay in Tennessee and to come home and help take care of my mother-in-law and my wife's sister because they were aging and healthy, not too healthy anymore. So we decided to come home. So we were living in our motorhome that we'd been living in for 3 years. We were living in it on the farm, waiting to find a house to buy around the area. I noticed the first time I understood that Nick was at the farm was he came by the motorhome and took a lock off of one of the buildings. And I saw him take the lock back to the pole barn. And I thought that was kind of strange. So I got up and got out of the motorhome and started walking back there, and he had left and went around the building to go to elsewhere. And I looked and I noticed that's not my lock anymore. And I saw him go up to another building further away on the property and park. And I walked up there and I said, Nick, what happened to my lock? And he went ballistic. He started hollering and screaming about, I cut that lock off and I cut it off and threw it in the woods, and it's put that lock on there so I can get in there because I can't get in there if that lock, and on and on. And so I said, so you took one of the other locks and put it on there? That's what I did. I said, well, I'm going to go get the keys and just check out the shed. And the keys happened to be for her locks, happened to be in the house. So it's about 150 feet, maybe more, from where we were all the way to the house. And nobody was home. There was nobody at the farm. All that 150 feet, all I got was pushing, shoving, screaming, and hollering, and things like, Nick, calm down. If you hit me, you're probably going to go to jail. I'm not afraid of jail. I'm not afraid of the cops. And it was loud and spit flying and really tough. I went in the house, got him. He came in and screamed and hollered the whole time through that. I went out and we were walking towards the woodshed. And we went towards the woodshed, and he went in there and he started screaming at me for the whole woodshed being cleaned up because my mother-in-law wanted it cleaned up. So we cleaned it up and we put his hunting gear out in the wood side of the woodshed. And that made him all mad. And he was screaming and hollering about that too. So I said, the heck with it. And I walked away from the woodshed and I was going to go to the pole barn. And I just rounded the corner of the woodshed and bam, I took it right in the back of the head. And I don't think I went down, but I know we were tangling for a while, and I remember looking up, and he put a metal item in his pocket, and I had seen his brass knuckles before because he was pretty proud of them. And to me, it looked like brass knuckles again. And the hit that I sustained, I knew I got hit by metal, and it was tough. It was really hard. So there was a tussle. There was trying to figure out what's going on. And blood is just going all over from me, and we were fighting, and I was losing. And a little bit of a difference between a 63-year-old guy and a 42 or 43-year-old guy at the time. He finally stopped fighting, and it was weird because we were fighting, and I had lost my glasses, and all of a sudden he hollered out, "Stop!" And I remember hearing that, "Stop!" And he stopped and got off of me and walked away. I was like, well, that was really weird. So he went up towards his truck, towards that building that we had walked away from. And I had to go into the motorhome to go after my phone so I could call 911 because I was just gushing blood everywhere. And 911, the first thing they ask you is, what's the address? Well, I've known my wife for almost 40 years at that time. I knew the address. I've been to the farm 100 times. We stayed up there for a year at one time. I couldn't remember the address to the farm. So I had to walk out to the street and read the fire number to 911. That was kind of weird. That was it. I knew something was wrong. So 911 showed up. Or no, before that, I'm standing out there just waiting for the police to show up and the ambulance. And Nick comes flying by in his truck and he just goes right on by me and left. And sheriff came and the sheriff took all sorts of pictures and my statement. Ambulance came and they dressed up my wounds. And then we were able to call my wife because she was in town. Don't remember why, that she was running errands with her mom and actually Nick's mother. And she came back and ended up taking me to the hospital, Burnett Hospital. I ended up with 2 1-inch wounds to the back of my head, black eye, scratched through the neck. They took a CT scan because they were looking for brain injury from the impact, and everything was okay for that. They ended up cleaned up the wounds, and we went back home. So that was the story of what happened, to the best of my knowledge.
And I'll tell you, I believe him. I actually believe that the events happened just as he is describing.
I was kind of floozy there, so I'm not sure how long this whole fight lasted or anything. But we ended up buying a house in Grantsburg instead of Webster because I'm not comfortable being around Webster anymore with Nick living right in this area. So we've done certain things at our house. We have driveway alarms that alert us when a car or a person or a deer comes in the yard through the driveway. We have cameras and security lights all throughout the yard and around the house. We've got double locks on all of our doors. We made guns more readily available inside the house because we're nervous. We don't go to sleep without checking the locks all through the house. We just don't. With the track record Nick has left with us for over the last 20 years, I fear of getting shot from afar. I fear that he's going to be, I live out in the country, and I fear he's going to be out in the woods just like he always does. He's always out in the woods. And I fear for a gunshot one of these days. And I'm really nervous about that. It's scary. And I think he's a smart enough guy that he knows to do this when I'm alone, because he did that perfectly at the farm. He knew I was alone through his mother, that Ethel was in helping, and Ethel's sister, or Nick's sister, went somewhere else. He knew all this, so he knew I was home alone. So I'm paranoid of being alone. I'm very paranoid of being at the house alone without my wife. Nice part about it is Ethel's mom just fell and broke 3 vertebrae in her back, and she's now living with us. So I've always got somebody at home now, and it's a little bit more settling. Very careful about going out to the farm because you never know. Nick hunts there all the time. It's a little scary to go there, and I check out for cars. I check out the woods. I kind of look around and usually stop at Ethel's uncle's house, the next house down from the farm, and check in with him and say, hey, everything look okay out there? You know, and he knows what I'm talking about. You can't trust anyone that attacks you from behind. That's really part of this. That's kind of the end of the stories and how I feel about it. Now, if it's okay, I'd like to give my ideas of what should be done. I don't think it will be done, but it should be done.
I will allow you to give me your perspective. I just have a couple questions. What is your relation to Nick?
He's my wife's nephew. He's no relation at all to me. And right now, he's no relation to my wife, as she would put it.
Okay.
Those days are over.
Wife's nephew. And
so my wife cares for his mother.
Okay. Are they sisters?
Daughter. It's my wife's oldest sister, and
Oh,
we're
okay.
caring for my mother-in-law, my wife's mother.
All right, and then did your fear with Mr. Morseth start because of this incident?
I could say the truth is I knew he was dangerous well before any of this. There's way too much back history that I am not allowed to talk about.
Has he ever been violent or like this with you before?
Yes, with me before, with my wife, with my mother-in-law, with his sister.
Physical like this?
Nobody, not physical. There was something said to me by a family member that Nick's
Judge, I'm
95%.
gonna object to this hearsay or this type of, I mean, a lot of this is speculation of what my client thinks and this and what other people are saying. If they were so scared, I'm sure they'd be here testifying too, but they're not.
And yes, I don't need too much, not that it's going to go into or weigh any decision. You have the right to be able to tell me what you think from your perspective as a victim that you would like to see for sentencing. You do know that the state is arguing for what they are arguing for, correct?
Yeah,
Probation
a
and
misdemeanor is what I understand.
Correct. All right.
I take it, I don't know if I'm allowed to say that we lost 3 felonies out of this negotiations.
Per the agreement that's been reached, yes.
So can I talk again?
Yes.
You know, a 43, 44-year-old guy doing this to a 63-year-old guy. I mean, even if I was 43, same, just attacking someone from behind is just unacceptable. And if we let him go through with this, it's going to happen. You're going to have somebody else in this court with him. That's what this guy is. I was looking to see for some time served, 120 days of time served. I definitely would like to see probation imposed in state sentence. Like I said, the felony charge of attacking an elder is off the table, but boy, I sure thought that would be a good thing that would happen to him. And I guess that's pretty much it. I'd like to see something besides a ticket.
I think that if what the witness is saying is true, I think that he should be charged with at least 1 felony, because that would prohibit him from having weapons. And I think that needs to happen.
Going to Nick for this. I think a ticket is nothing.
All right, just so you know, it would never just be a ticket because they're asking for a criminal conviction with probation and withheld, at least that's what the state's arguing. And even if the defense, it does argue for just a fine, there is a criminal conviction that will take place.
Can I offer some photos?
It would, those would have, I believe they would have to come through the state.
I believe they're photos of his injuries.
Of my injuries.
Show them to Mr. Davis.
I believe these look like the ones from Discovery.
The first 3 came from the sheriff.
Are some of these not from Discovery? Did you take any of these yourself?
My wife did in the ambulance.
And I haven't seen any of these, Judge, if they're not from Discovery.
So that would probably be the start of the non-Discovery ones.
I guess I would object to anything that I'm just looking at last second here.
What about the ones that were in the Discovery? It sounds like there's 3 or 4.
I don't even know if those were the ones that were in Discovery or not. I have no idea to know that. And again, his statement was that his wife took those photographs.
The
Mr.
ones
Schmidt
in-
is looking at the ones that he believes were in the
I just had
Discovery.
those printed off this morning at the sheriff's office.
I could double check real fast because they're all on a shared drive.
Your Honor, can I ask a question?
You're not supposed to ask questions.
Oh, okay. Okay.
But if it's something that you can talk to the victim witness coordinator and she can make a determination of what she thinks.
Okay.
It might take me longer than I thought. I forgot they took a lot of photographs of Mr. Morissette too.
All right, then if there's an objection to the court viewing the photographs,
Those are all Morissette.
then the court will not look at the photographs. All right, is there anything further? Okay, then you can step back.
Nope.
Thank you.
I did find them. They are from the discovery, these first three.
The ones from the discovery, Mr. Davis.
Yes, if we're gonna do that, then I didn't know we were gonna be submitting those, and I guess I would wanna submit the photographs of my client, if he was all banged up and bloodied up too. I guess I would wanna have an opportunity to show the court those as well.
Then the court will not receive any photographs. All right. Basis for the agreement reached, Mr. Smith.
Thank you, Judge. There are three main reasons why. One, Mr. Morissette has one prior convictions from 2008.
What
Two,
was it for?
it was for battery, and it was similar conduct to this with a family member. Two, he fully paid the restitution in this matter. I should note that the victim was made whole through the Victim Crime Compensation Fund. So this is money that go to the Victim Crime Compensation Fund, which is a finite amount of money that go towards other victims. So I do want to emphasize how important it is to replenish that fund.
I am pretty sure that it gets taken from a lot more than what gets paid into it, especially since it's like restitution being paid by the perpetrators of the crimes.
Three, this is a battery where both people showed signs of injuries. I think Mr. Davis would agree the visible injuries on the victim here are much more severe than his client's. His client mostly had bruises. There was a profuse amount of blood with this victim because of the 2 lacerations that required Dermabond to seal. To that end, they would be able to raise self-defense in this case. All he'd have to do is testify and say, he hit me first, which is what he told the police. Because of that, I think the court knows there's a shifting burden that occurs.
When you said he told the police, who told the police?
Mr. Morissette.
Okay, all right.
Because of how the shifting burden works with self-defense, where the state would have to affirmatively prove who struck first, and also would have to show that the amount of force used was the legally allowable amount, with the burden on the state using Blackstone's ratio, which is what beyond a reasonable doubt and presumption of innocence are based upon. I think this is a reasonable compromise. I should add that this was a case with no witnesses and no physical evidence as to who started the fight.
All right, so you believe that it is in the public interest based upon all of those things that you have listed on the record?
Yes.
All of those reasons. All right.
I think it's in the public interest for every person to stay as far away from this man as humanly possible. Don't ever be alone in a room with him.
Mr. Morissette, I have in front of me a plea questionnaire waiver of rights form. Do you recognize this document?
Yes, Your Honor.
Did your attorney thoroughly go over this document with you?
Yes, Your Honor.
Did he essentially read it to you word for word?
Yes.
Do you understand everything on the document?
Yes, Your Honor.
Is that your signature on the document?
Yes, Your Honor.
It states that you're pleading guilty to a battery charge. Is that correct?
Yes, Your Honor.
You're 47 years old. You have 12 years of schooling. You can read, write. You understand the English language. No drugs, alcohol, or other medications, correct?
Yes, Your Honor.
No mental illnesses or disorders?
No, Your Honor.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
Did your attorney go over with you the maximum possible penalties you face?
Yes, Your Honor.
I'm pretty sure as far as the mental disorders goes, I'm pretty sure that it's just not been diagnosed. Just because it hasn't been diagnosed yet and isn't officially on some piece of paper does not mean that he doesn't have mental disorders.
You're 47 years old, as I went over before. You have a criminal conviction, but only one conviction from 2008. Is that correct?
Yes, Your Honor.
And that is another battery conviction, correct?
Yes, Your Honor.
Did your attorney thoroughly go over your constitutional rights with you?
Yes, Your Honor.
They're identified on the first page of this document. Do you understand them completely?
Yes, Your Honor.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, Your Honor.
Do you understand that once you give up your rights, you can't come back and say, you know what, Judge, I want to have this, I want to have a jury trial?
Yes, Your Honor.
Do I need to go over your rights with you again, or do you fully understand them?
Yes, Your Honor.
You understand them?
Yes. Yes, Your Honor.
You understand them?
Yes.
Okay. Now, do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
Do you understand that the state would have to prove that on or around July 7th, 2024, in Burnett County, Wisconsin, you caused bodily harm to victim 1 by an act done with intent to cause bodily harm to that person without that person's consent? Do you understand what the state would have to prove?
Yes, Your Honor.
Do you understand that upon conviction, you do face a fine of up to $10,000 and incarceration of up to 9 months or both?
Yes, Your Honor.
Do you understand that there's an agreement that's been reached where the state is going to argue for probation and a withheld sentence, and your attorney is going to argue, or is free to argue, for anything the defense feels fit? Do you understand that I'm not bound to follow either of the side's arguments?
Yes, Your Honor.
I could sentence you all the way up to the maximum penalty today if I thought it was warranted.
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Did you go over the criminal complaint with your attorney? And in particular, the section called the probable cause section, where it basically says what happened and why you were charged with crimes?
Yes, Your Honor.
For the most part, are those facts accurate?
Yes, Your Honor.
Are you admitting here today that you in fact did cause a battery to victim 1?
Yes, Your Honor.
And you did not have consent to do so?
Yes, Your Honor.
Are you pleading guilty because you are guilty of this crime?
Yes, Your Honor.
Mr. Davis, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty, Mr. Morseth?
No, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes, Your Honor.
and voluntarily?
Yes, Your Honor.
Has your attorney represented you competently?
Yes, Your Honor.
Has he answered all of your questions?
Yes, Your Honor.
Has he looked at this matter thoroughly?
I believe he did, Honor.
Did he look at the discovery and the evidence and talk to you about that?
Yes.
Did he discuss any possible defenses you have or a lack of defenses with you?
Yes.
And are you satisfied with his services?
Yes.
Do you have any questions for the court or for your attorney before I proceed?
Mm. Oh, yeah.
Then as to count 4 battery, how do you wish to plead?
Guilty, Your Honor.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of battery. The other counts will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument, Mr. Schmidt.
I think the court needs to place the defendant on supervision. I think what the court's heard today from the victim is extremely impactful. And I want to be clear. I believe that it happened the way the victim described it, full stop. However, I am not the plaintiff for Mr. Yeager in a civil case alleging a tort battery, which would be how you describe a situation where you go in front of a jury or a judge and say, hey, who do you believe? Do you believe Mr. Morseth or do you believe Mr. Yeager? I'm the state, I'm representing the public interest, and I'm representing to the court about what we can know to 93% chance 10 guilty people go free is better than 1 innocent person being convicted, Blackstone's ratio. To that end, what I would say to the court is, because of the nature of his past conviction in 2008, albeit extremely long ago, the court should have paused to place him on probation still now. The reason for that is the 2008 conviction also involved assaulting a family member. It was also involved holding a metal object. In that case, it was a pistol and a flashlight where he struck a family member on the head, causing head injuries. This is similar, very different object. The victim believes it might have been brass knuckles because he's aware that Mr. Morseth owns brass knuckles. He couldn't see very well, knew it was something metal. Mr. Morseth, when he was interviewed, said, I was holding my keys because he was changing the locks at that shed, and it was the keys he hit him with. So it's still a metal object either way. And because of the 2008 conviction, he should know how serious hitting with any metal object can be, whether it be brass knuckles or keys or a flashlight or a pistol. Because of that, and because of also, you know, Mr. Yeager alluded to in the family, there's lots of concern about him that goes beyond the 2008 conviction, whether there's some allusion to it's not physical, but everyone's afraid of him for some reason other than physical. That's another reason for the court to have pause and wonder if there's anger management issues or if there's a greater domestic violence issue that needs to be looked at for Mr. Morseth. I know this isn't domestic violence because obviously Mr. Morseth has not lived with the victim here. But when I use the term domestic violence, I'm not using the statutory definition. I mean, violence against somebody in the family, which I think is probably the layperson understanding of the term. I think that the court's likely going to hear something to the effect, hey, judge, this happened in 2004. He's been on bond. He hasn't done anything since. So there's no need for probation. To that, I'd say just because he's been on bond doesn't mean he's been doing interventions, doesn't mean he's been doing MRT or thinking for change or cognitive thinking things that could benefit his family. And it doesn't give the victim the added benefit of at least some peace of mind that DOC will be monitoring him for this time. Thank you.
Thank you. Mr. Davis.
Thank you, Your Honor. Well, Your Honor, I believe it's a serious offense because it's a criminal conviction, albeit a misdemeanor. He's still not convicted of a misdemeanor battery. But when I look at, I've heard the victim, I've heard his position, I've heard the state's position, but my client has not changed the position one bit. My client did not start the fight, was not the aggressor. He was at his grandmother's farm. He had permission to be there, and no one had permission to put a lock on the shed. And the grandmother instructed my client to remove the lock, and he did so. And that really upset the victim to no end. And the victim was the one who started this, was getting in my client's face, and then the fight ensued. My client never had brass knuckles. He never had any kind of weapon like that or anything. The reason he had keys in his hands because that's what he was carrying. And as he was getting choked and beat, and he was fighting back, it would be the only thing that he had in his hands, metal, would have been a key or keys that he had, which he was out there with. But he wasn't using them as a weapon. He was getting attacked. I believe that my client could have stopped when he got the advantage. And I think at that point when he didn't, I think he even told the officer it was fight or flight. And I think his adrenaline was so much as that he continued fighting when he could have clearly stopped. That's the battery. He had no permission to continue on. It should have been ended and they both should have gone their separate directions. He's now guilty of that. But I would like the court to be aware, the victim is talking about this, but there's been lots of issues at that farm, include Dennis Steverman and Wyatt Steverman would be the nephews of the victim and my client's cousins who had also had altercations with the victim at the farm. Because the victim wants to pretend that it's his farm and he doesn't like any other family members out there and he tries to control things. Now, my client, I'm here to argue and let the court know why the victim was the aggressor and why he was out there. My client has permission from his grandmother to be out there, and anytime he's out there, he gets permission from her. And it seems that the victim doesn't like my client or any other nephew out there. And he doesn't like it and he doesn't want anyone out there. But in any event, this is not the first instance that involved my client and physical altercations. It's also been two of his cousins that have had to be in similar situations. Maybe not to the extent of this, but it's an unfortunate situation.
Are they just as crazy as he is? Because he's crazy. I think they need to put a lock on this farm entirely. I think they need to stop everybody from going to it. This family, there's something wrong in the bloodline.
But I don't want the court to think that my client is a dangerous human being and he's out there trying to impose his will on anyone that's at his grandmother's farm, because that's not true. Another thing is a little disingenuous is for 20 years, he's been known that my client's dangerous or he's fearful. 20 years is a long time to contact law enforcement or get restraining orders if those types of activities were occurring. I don't believe they were. I think there were also concerns of alcohol use, not by my client, but by the victim. And it has not been the first time that's been a problem out at the farm or other places near the property.
You can't just go get a restraining order on someone without cause. Unfortunately, the law requires that something take place in order to get that restraining order. So that argument is ridiculous. You're an attorney, you know better. You can be scared of someone, you can know someone's dangerous, but until they attack you or surveil you or do something to you, you can't just go get a restraining order on them.
In any event, my client's here taking responsibility. He now has a conviction, battery conviction on his record. What I want the court to know, and yes, we are thankful, my client is thankful, you gave him the opportunity to keep making money, and he worked lots of overtime to pay that restitution up front, Your Honor. And that restitution amount was, I thought, one of the more significant amounts that I've ever had a client come up with, which I believe was $5,909.06.
It was revised to $6,872.84.
So even more than the initial amount that I had then. And he's paid that, and he had to work additional shifts. He works out of town. As you allowed him to do that, he would go and he works in Minnesota or another state, and he was able to pick up additional shifts to make sure that that restitution was paid. Again, and the reason I'm making an argument for cost on this, it's not just because he's paid the restitution. And my client does not want to have any contact with this individual. And my client still has a great relationship with his family, maybe not the victim's wife. And I didn't know that the victim and his wife were even still together. I know there was issue with those two within the past year or two. And I think the state's aware of that. But in any event, my client wants no contact with the victim. He doesn't go or do drive-bys. He doesn't go anywhere near the victim and never will, period. Never, ever happen. He doesn't want anything to do with that part of the family. But I can tell you that Nicholas wasn't drinking, Nicholas wasn't using drugs, and he's never had a problem with drinking or drugs. He's made all his court appearances. I know this has been very serious for him. He's been very stressed out about this. But I think that putting him on probation, yes, the state then, the Department of Corrections can monitor him and make sure nothing like this happens. The last time it happened was 17 years ago, 18 years ago, where he had his one misdemeanor. That's the only record he has. That is extremely long time ago. But I think that probation may not be well suited, because I think those resources could go to people that have addiction issues or need special treatment and things like that. And while I do agree with the state, because I'm not going to lose my reputation in this court or any other court, yes, I agree that the damage was much worse on the victim than it was on my client. That's factual. So I will agree with that. But my client was roughed up very well too, but not to the extent as the victim. But my client has not had any bond violations. He's never tried to mess with the victim, intimidate him, hasn't talked to grandma or any family member about it. He has stayed completely clear of it and followed every court order. And so I think he's earned the right. He's now a convicted criminal with this today. And I think he's earned the right for this to just be a court cost and fine. And again, I'm not trying to be insincere about this, but again, my client did not start the altercation, but I do believe that he could have stopped at the appropriate time. And again, the fight or flight is adrenaline. He continued on, and it should not have happened. And for that, he is wrong, and he should have never done that. And he does apologize for it. Nick is a very shy person. He doesn't do well talking. As you can see, even when he's answering your questions, he's shy. So I'm speaking on his behalf today, Your Honor. Thank you very much.
All right, thank you. I know you said you're speaking on his behalf here today, but Mr. Morseth, you have an opportunity to provide anything to the court, to let me know anything you want me to know. If there's something that wasn't touched on, or if there's something that you feel needs to be corrected or you need to add, this is your opportunity.
Yes. Yes, Your Honor, I'd like to say something.
Then please put the microphone closer to your mouth.
Is that
Thank you.
better?
Yes.
Is it on?
Yes, it is.
Yes. My uncle, Rick, I looked up to this man for a very long time. It was a bad situation, like you said in the previous hearing with this. There's victims on both sides of the spectrum. I remember that. I remember you saying it clear. And I feel like I was a victim, and I'm sure he feels like he was a victim. Should have never happened, or should have never got to that far on both sides of the spectrum, where he aggressively attacked me, not just once, but 3 times too. Kept coming at me. That's where I come up with I said the fight or flight reaction. I could not get away. And I kept telling him, stop. When we were on the ground, stop. Where's your glasses? Where's my glasses? And after he punched me in the private area, I ended up kneeing him in the face. And that's how the glasses got broken. That's how the black eyes happened. That's when he finally stopped. I said, stop, Rick, we're done. No more fighting. I don't want to do this. And that's when I was able to actually vacate the property. But not until then, he mentioned to me, and I was scared for my life. He said, basically, I'm going to kill you. And I know he has a conceal and carry license. And that's when he had that. He got that prior to before traveling for his safety and his family. I think he has I believe that he has some mental anguish of fear for his life from his travels. And I have no intent to do any harm to him, his family, or anybody. It was just a bad situation that it blew up and got worse. And I've learned from my mistakes, and I'm just as anybody else learns from their mistakes. If they can learn, they're going to better themselves, Your Honor. And this has been a long haul for me all this whole time. Working, bonding, making memories with my kids, because I had reconsidered that, and it's been hard. It's been hard for me too, physically, emotionally, because I worry about seeing my grandma if they're there. So I call, I try to avoid them so there ain't no 2 people at the same time with the restraining order. It's been hard. And I know my grandma's getting up there in her years, and I don't know how much more time she has left. So every moment I can spend with her, it's a gift.
All right, thank you, Mr. Morseth. Well, in sentencing an individual, you haven't been in front of a court for sentencing for a very long time, and things have probably changed since 2008. The court needs to look at the nature and the gravity of the offense. How serious is this case? I have to look at you, your character, your past criminal record, any rehabilitative needs you may have, among other things. I have to look at the need to protect the public. I have to look at the impact on the victim. I have to look at other things as it relates to the public and the public interest. In looking at this case, you are pleading guilty to a battery, to laying your hands upon another person without their consent and injuring them. That is serious. That's a serious crime. You've done this before in 2008, and it sounds pretty similar from the 2008 conviction. So that's on the negative side. On the positive side, you haven't been convicted of anything similar since 2008. It sounds like that there's a lot of family discord. It sounds like, but it's hard for me to gauge and hard for me to tell. The victim, Mr. Jaeger, was very convincing, and this has impacted him significantly. And I understand it has impacted you as well, but you're the one seated in that chair. You're the one who is now convicted of the battery. What exactly happened that day? I don't know. The only two people that really know are you and Mr. Jaeger. Only you two know exactly what happened that day. And it sounds like it was awful, traumatic, not only physically, but emotionally as well. And it didn't only impact you two, it impacted your family and others. And that again makes this a more serious crime. You did plead guilty. You are now, again, a convicted criminal, I guess. You are a criminal. You've been convicted of a crime. You worked hard in order to pay off the restitution, and almost $7,000. That's a lot of money to prepay. And you prepaid most of your court costs and fees ahead of time. So to the court, that looks like you're taking it seriously. There are some things to consider with the state's argument in the fact that there are things that perhaps the court needs to look at. Because again, even though it was from 2008, it is so similarly related of a crime that there's something that goes into that. In protecting the public here, number one, it's protecting Mr. Morseth. Sorry, not Ms. Morseth, Mr. Jaeger, protecting him and protecting, his environment. And then the court also has to look at others. Do you have needs that you need to address? Are there resources that you need to reach out to, such as anger management or criminal thinking programming, like Mr. Schmidt has argued? When we're looking at this case, I think it is a positive that you've prepaid the restitution. It is a positive that you are admitting to your guilt. But I do see the state's perspective and argument that there could be other things that you need and you need to address. But that would be up for probation to determine. Probation's the one who will know if you have things you need to do, or if there aren't things that you need to do, how often you need to see probation, if at all. But I think the seriousness of this case does call for probation. So I am going to order 1 year of probation. 1 year of probation, and I am going to do a withheld sentence. Generally, I would do an imposed and stayed sentence, but quite honestly, I want you to understand that there could be a seriousness of 9 months of jail hanging over your head. So if you aren't going to abide by your conditions of probation and do what you need to do, you could go to jail for 9 months. That's a significant amount of time. I believe you were arrested, but I don't know if you've sat any days in jail. Any overnights?
No.
Overnight, I believe.
It was overnight? So,
Oh, no, it was actually longer than that, 'cause I got transported down to Polk County. So I don't know how many days it was. to be honest.
Judge, I'll have to look into that. I don't have the amount of the days.
so, okay, well, let the court know within 7 days what the jail credit is. But Mr. Morseth, you could have 9 months of jail. That's a significant amount of time. I do want to see as conditions of probation, an anger management course with the department's choosing, and a criminal thinking program. Absolutely no contact with Richard Jaeger or his wife, but there's a restraining order anyway, an injunction. No abusive contact with any family member. Absolute sobriety. You don't drink or do drugs anyway, but probation won't allow you to do that anyway. I'm ordering restitution in the amount of $6,872.84. $518. Oh no, actually $500 in fines and fees. So I guess you have prepaid your court costs as well. You should have all of that covered. Any conditions that I'm missing for probation?
No weapons whatsoever. And can we get a mental health eval? Please.
Not for me.
You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. The court is going to order your DNA. You have to provide your DNA to the sheriff's department. This would be a crime that you could request it be expunged through a written letter to the Department of Justice. You do need to report to probation immediately. Restitution, the last one we had was. There's a revised, well, or is there was a revised one on August 6th. Was there, or where was there a revised one to a lower amount? On May 30th,
No, I've got the receipt right here, Judge. You were right, the $6,872.84.
Yeah, he paid $6,000.
And he's got the receipt for it as well.
There was one in there. Document 16. For $6,872.84.
Well, he's got document 15 on his, but anyways.
Well, yeah, mine is the sealed one.
Oh,
So it's document 15 is the one. Document 39. So I'm not sure exactly what the restitution is. He's prepaid $6,872.84. That's one of the restitution supplements that we have. 20 days to appeal. You need to contact probation. Is your address Trailway?
Yes, Your Honor.
Telephone ends in 3699. You must report to probation immediately. I believe they close at 4, I think, I'm not certain, but I am going to give you until tomorrow at 4 to report, just in case they are closed. So again, provide your DNA, go to probation and get that set up, and you should be free to go.
We'll talk next week. Make sure you sign up for probation.
And we are adjourned.
No. Where's the probation office?
It's kitty corner off the highway.
Oh, over.
Yeah.
Okay. Where was that?
So go see if you can get there today.
Yep. Sitting back.
Doris. Yes, I think she's got a piece of
These are
paper.
what it's not. Who else is not looking for an attorney? You, sir, in red. What's your name?
Robert Jones.
Can you say the last name again?
Jones.
Jones. Okay. We will go on the record in the matter 25 CM 229, State of Wisconsin versus Robert Jones. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. Jones in person without counsel. We're set today in this matter for an initial appearance. Before I go down that route, Mr. Vila, is there an offer that could be presented?
Yes, Your Honor. The offer is to amend the charge to a civil citation.
All right. Do you understand what that means?
No, I don't.
He's saying he's going to ask the court to amend it to like a traffic ticket. Like
No, I'm not pleading guilty to anything. Can I explain what happened? I mean, just a little bit. Okay, well, I'm 13 miles away from my house.
I have to warn you though, anything that you say today is on the record and it could be used against you.
That's fine.
Okay.
Okay.
So I just have to warn you of that. And it sounds like when you're talking, you're going to talk a little fast.
Okay.
Please slow down.
Okay.
I have a court reporter who has to take everything down. Okay.
Okay. So I was at my
But again, everything can be used against you.
Okay, that's fine.
Further.
Sorry, I was muted. A little fast. This guy sounds like he's on speed. That poor court reporter.
Okay, I was at my girlfriend's house and the cops got called there for a matter or whatever. So I had left and I guess the cops had went to my house and looking for me. So I went back to my girlfriend's house and then because I heard the cops were looking for me, so I went there and waited for them.
No, I need to understand because I thought you lived in Minnesota.
No, I live here in Wisconsin.
Can I get an updated address then? Because
Yeah,
I have a St. Paul address.
Yeah, it's in Siren.
Okay. And I have a telephone number ending in 5071.
Yes, ma'am, that's my phone
Okay.
number.
Now again, remind you to just be a little slower.
Okay.
Okay.
So the cops, I heard they were looking for me, so I went back to my girlfriend's house. So they come up and they resolved the issue there. And then the one cop, I mean, I said something smart ass to him. I'll admit to that because he's like, how old's that girl? The girl, and I told him her age and I told him my age. And he like, from right then on, he was just giving me a bunch of shit. So
You're in court.
oh,
That's your
a bunch
warning.
of garbage. I'm sorry. But anyway, so we finished there and they didn't have no charges on me or nothing. So he says that we're done here, but he goes, I'm going to put you in custody and bring you back to your mom's house on another matter. So he puts me in the car. We go back to my mom's house and there's my friend's truck was parked in my driveway, right? So he goes, can I search this truck? I said, I don't care. I mean, that's not even my truck. You know what I mean? So he goes in the truck, he comes out and he finds a pipe, a marijuana pipe. And he says that he put it on me, that it's my pipe. I'm 13 miles away and it's in someone else's truck just because it's in my yard. How is he putting that on me? He's giving me possession of a pipe that I was 13 miles from it and it's not even in a vehicle I own.
We're speaking real fast. Speaking so fast.
It's just frustrating to me. I mean, I'll be 60 years old. I've never been in trouble for drugs in my whole life ever. I don't do drugs, nothing. And he's trying to put this stuff on me and it's really frustrating.
I understand. I just have a few because you said he wanted to take you to your mom's house. Do you live with your mom?
Yes.
Okay.
My mom's 85. I came here after my brother died to take care of her.
See, because it was confusing when you're saying my house, then my mom's house.
Well, my mom's house is my house.
Taking you to your mom's house so she can ground you.
Yeah, pretty much.
All right. So what I'm hearing from you is that you would like an opportunity to talk to the DA to see about what you can give to him, because the DA has to ask the court to dismiss it.
Yes. I mean, I don't know how I'm being charged with something when I ain't nowhere near it and it's not in any of my vehicles that I even own. I don't know. He was just mad because I made a comment to him about him not being able to get no females or whatever because my girlfriend was younger. He got all upset and I did that and it pissed him off. And then he's trying to pin this bullcrap charge on me.
Here's the thing, that's second time.
I'm sorry.
Third time's a charm and you get to sit a night in our wonderful
Won't
hotel
happen
jail.
again. I promise.
Okay. It's great accommodations over there.
No, thank you.
So anyway, what I'm going to do is I'm not going to go through an initial appearance right now. I'm not going to take a not guilty plea because that allows you more ability down the road to do motions. Okay. But what I'm going to do is do an adjourned initial appearance for another day. I'm going to have you go down to the district attorney's office when we're done here, set up an appointment time to meet with Mr. Vila so that you can talk to him about all of this. And if you have any proof or evidence or whatnot, you got to show him. Okay.
Okay. But all right.
It's just like if it's not.
Why do I have to prove my innocence? Don't they have to prove my guilt? I was
They do.
nowhere near it though. I don't understand how he can put it on in my pocket if it's nowhere near me in someone else's
And
vehicle.
here's the thing, Mr. Jones,
Yes, ma'am.
the court as well as the state only gets the little bit of information that comes from that initial contact with the police at this point in time. So I don't know what Mr. Vila has, but I can tell you all I have is what is cited and stated in that criminal complaint.
I understand.
And so right now, your chance is to go talk to Mr. Vila and explain it.
Mhm.
I would strongly suggest no caffeine that day, so you can just be a little bit slower.
I just feel like I'm being messed with, so.
And I
mean,
understand, and that's why I'm hearing you, and I'm just going to move this to another date and time to give you that opportunity, okay?
Thank you.
I'll even give you a little bit longer. Is a month okay, or would you like it a little bit further?
Whichever, I don't mind. I mean, if it's gonna take a while to get to talk to him, probably a little further then.
I don't know if it'll take a long time to get to talk to him, but I don't really know his schedule, except when he's in court.
Okay.
Well, I guess, I know my schedule's pretty booked until then, unless a trial comes off, and I'm not sure about that. I could do December 11th at 3:15.
Fine.
So I know his story went very fast, but what it sounds like from what he's describing, he was at his girlfriend's house 13 miles away. That truck was parked at his mother's house. The officer was at his mother's house looking for him. And when he got there, the officer, my guess is the officer had already been peeking in the windows of the vehicles on the property and had suspicion that the pipe was in there. Because why did he pick that one vehicle when he has stated there's multiple vehicles on the property? So the officer asked if he could search it, and the guy said, "It's not my vehicle, go ahead." And of course, he found the pipe. So he was 13 miles away. The only link of this pipe to this man is the fact that the vehicle was parked on his property. But does that automatically make it his possession? Because technically it's his mother's property. The officer could have just as easily charged her with it. This one's a sticky case. And I really don't see the state being able to meet its burden.
Okay, December 11th at 3:15. And I'm telling you right now, it's very important that you go right to the DA's office and you schedule an appointment with Mr. Vila.
I'm gonna do that right away.
Okay?
Yes, ma'am.
So you can come get your notice and you're free to leave.
Thank you.
Thank you. Mr. Jones. We will go on the record in the matter 25 CM 229, State of Wisconsin versus Robert Jones. The state appears through Assistant District Attorney Jose Vila in person. Mr. Jones appears in person without counsel. We're set today for an initial appearance. An offer was presented. Are you accepting the offer?
No,
You want to go to trial with this?
of course. Yes. Yep.
Would you like to have a court trial? Have me decide this?
It doesn't matter. I mean, as soon as the facts are presented,
That's right. This is that truck and that issue.
yeah, I
All
was,
right. So, Mr. Jones, do you understand you would have the right to have a jury trial, or you could say, you know what, I want to argue to the judge and have the judge decide? That's your right. Do you understand that?
yeah, would I be able to have like the police officer that was there in court too and stuff? So,
For me, yes.
okay, yeah,
Because-
definitely. I would do the judge trial then.
But I mean, you would still need to figure out how to subpoena him and do those kinds of things though too. But that's with anything, but yes, they would be able to testify and you would need to provide your witness list and the state would provide their witness list and you'd be able to determine who they are calling to testify, and that may mean that you don't have to subpoena them. Okay?
I just,
So-
yeah, okay, I get it all, but
Yeah.
Your Honor, just to clarify the record, the offer for the citation was made at the previous hearing we had, and the follow-up offer was made since that new diversion program at the DA's office took place, that if he just did a class, we dismiss this altogether. He also declined that. I just want to make the record clear.
can I speak? I just,
I know your side. I know.
no, I understand that, but just because he probably doesn't, but I mean, I'm 13 miles away and there's a pipe in someone else's truck and the cop takes it out of their truck and says, I'm charging you with this.
I understand where you're
So
coming
I
from with
just-
that. So
Okay, okay.
you said it at the last hearing.
I know.
You think we could get this done in half a day, Mr. Vila?
Yes, Your Honor, if not less.
And this is your case?
Yes, Your Honor.
I mean,
Yeah, I don't think we would even, how many witnesses do you think you would have?
2.
How many witnesses would you have?
just my mom that saw him take the pipe out of someone else's truck and say it's mine.
Your mom?
My
and
mother.
The law enforcement officer probably, or they're probably gonna call him.
Well, it's don't they have to prove that?
They have to prove beyond a reasonable doubt, yes.
Okay, well, then I don't need any witnesses, really.
That's the dumbest statement you could make, dude. If your mom witnessed that happen, then you want her as a witness. Pro se's.
Okay, so
I mean, can I just say one thing though? I mean, I'll be 60 years old on Wednesday. I've never been in trouble for drugs, misdemeanor, criminal, nothing on my whole record. And they want me to,
I understand, and you can make those statements.
Okay,
and those
gotcha. I'm
arguments,
sorry.
But right now, let's just try and
Okay.
get this scheduled.
yes, ma'am.
How about January 22nd at 9:30? And I would think 2 hours would be sufficient. Or the rest of the morning. Let's just do the rest of the morning. January 22nd from 9:30 till noon, okay?
Sure.
All right, so anything else?
No, for me.
Does the
Alright.
court want to put any kind of scheduling order for Mr. Jones to follow on this?
Mary will get one mailed and get it out.
Fair enough. Thank you.
What's that?
You'll get, my assistant's gonna do something called the scheduling order. It says when the trial is, and it says, when your witness lists are due
Okay,
and
great,
those
great.
kinds of things.
Okay.
So you should expect that in the mail next week or so,
Okay.
okay?
Can I ask one other question?
Yes,
I mean, what's the maximum penalty on this?
30 days.
Okay, perfect. Great.
Yeah, it's a $500 fine, 30 days.
Yeah, and
You
it's,
know?
it's drugs on my record that I don't even do drugs. So it's like,
Again, I understand where
I'm
you're coming
just
from.
saying though,
You're
otherwise
gonna
I
get
would,
charged.
I would have just took the citation and just been done with it. But it means a lot to me, not been in trouble my whole life. So I'm not gonna start now.
That, I appreciate that. Okay, so we'll see you on the 22nd, okay?
Yep, I'll
Thank
be
you.
here. Thank you.
You can come get your notice if you want it, sir.
Sure, I would. I had to call. I almost didn't get through.
Definitely a man with a whole lot of pride. The state's offering that if he takes a class, they'll dismiss it 100%. I get it, dude. You feel like you're being wronged. And if it legitimately is not yours, you're going to fight 10 times harder. I get that. But on the same token, what if you lose? And you no longer have the benefit of being able to just take a class that you don't need anyways, if what you say is true, and walk away from it with nothing on your record still. You're taking a risk of getting a conviction. It's dumb. Swallow your pride. I mean, even if it's just a matter of the fact that it was in a vehicle that was on his property, I mean, they can make a case out of that. I don't know why the officer chose that specific truck. Maybe it was intuition. Maybe he, saw something, an Altoids container or something that drew suspicion. Who knows? But what I do know is that guy, he's not doing himself any favors by having so much pride. I understand it, but on the same token, I don't. He needs to be like a snake and just disconnect his jaw and take it in whole, digest it later. National Geographic style. It's not a perfect system, but I think it's the most fair that there is, in my opinion. I know. It's my fault. I didn't think before I spoke. You do win, Ice Rose. What's your prize? Oh, I have a present. Apparently, it's from Charlie. He asked me if I got a package, and I was like, oh, but I did. Yeah, but I think he wants to try it out of pride. Okay, I'm gonna open a present. Sort of. I'm gonna start to open it, and then the bag's gonna get stuck. It's a twofer, whatever it is. There's two of them. Oh, come on. I've got to be smarter than the bag. There we go. I just had to do it right-handed. I'm left-handed, though. Should I be scared? Actually, this isn't from Charlie. Nope. I'm sorry. But I know exactly what it is. It's the solar-powered mat that I ordered for the kitty cooler that I made. So I took a cooler and I carved I used a saw and I carved a hole in it, and then I put duct tape all around the hole so that there wouldn't be any sharp edges, and so that the insulation on the inside of the cooler wall wasn't exposed. And then I put a blanket in it for the kitty cats. But the one thing that it doesn't have is any form of heat source. This is a solar powered mat, so the kitties can stay warm when they go outside. If because they get out. I can't stop them. I can't chase them. I know this is gonna be for you, Billy. And I got 2 of them so that if I have to wash one, I can still have one out there. Oh, I'm so happy they finally came. That took forever. Hi, Billy. The treats are up on the bookshelf, sweetie. I'm sorry, but you're not getting any more. You're tubby. You need to go eat your real food and not have treats all the time. I love you. You look so happy to be my cat. You look thrilled. You are my baby. I love you so much. There you go. Oh, Joey bag of donuts. That's beautiful. Happy heavenly birthday, Dad. Well, it's a little kitty hotel. And surprisingly, the possum hasn't found it yet. Maybe it has, and I just haven't seen it. Oh, thank you so much. I know. Especially since my address is public and anybody can send me anything. I'm still waiting for, somebody to risk a felony. Oh, Nana Laura and Manuel and Charlie and C-Rex and Jerry, they all know what I mean. Especially if I put kitty kibble in it, because that's Possum's favorite food. I know this because I used to put kitty kibble on the deck for the kitties. And I got to pet a possum one night. Oh, Ava. You are so spoiled. You are so jealous. How dare I? How dare I talk to anybody else without me petting you at the same time? Well, Billy's actually staring at Ava, and I'm sure he's getting ready to strike. Billy loves antagonizing. Oh, I don't think I would want a sloth. I mean, they're cute and all. I would love to have a possum, though. Possum, a squirrel, and a skunk. I would love. Those are like my 3 if I could have pets. Oh yeah, she's being a jealous little baby and wanting all the attention. Okay, I give you cuddles. Cuddles for kisses? Got it. All right, guys. Thank you so much for coming out and spending this time with me. She already got her 3. We're all trying to be less chunky in this house. you spoiled. You spoiled girl. Yes, you are. But you're a good girl. You gotta go potty. Do you gotta go outside? Yeah. Okay. Yeah, I'm working on it, Earl. Billy is cuddling where the treats were. Who did you get into a fight with? My goodness. He got into a fight with somebody. Did you win? Are you winning, son? I got cat fur everywhere. I love you, Purple Queen. Ava's biggest fan. You know what I mean. Oh, wait, by the way. Look at his grumpy butt. You're on camera. You want to smile? You want to smile? No, you don't. You got the tail going. He's like, touch me, I dare you. Earl does it. Earl does it all the time. I have, on like Ghost Adventures, when people have like the demon scratches down their backs, that's what I have. But they're from Earl. Tiny Kitten's done it a couple times, but Tiny Kitten typically does it and then sits on the back of the chair. Like, she doesn't actually climb my back. Earl climbs my back, and he was 13 pounds at his last vet visit. I'm thinking he's about 15 now. And oh boy, it hurts when he does that. I've got on my neck, I think it's mostly healed. But on the back of my neck here, he got me real good. Oh yeah, yeah. I love these guys so much. I do. I've really got to check that security cam footage and see if it's safe to post. I mean, it'll be somewhat embarrassing because, it's me in my bed and I've got my BiPAP on, but I don't think you can really see that part of it so much. It's black and white, so that's helpful for me. But Earl really does. He patrols the bed, and then he looks out the window, and then he turns and he comes up and crawls right on my belly and goes back to bed. It's so cute. And then seeing Billy cuddled in my arm like a giant baby. The giant baby he is. It only does like 30 seconds at a time though. So like there's multiple clips, but I would pick, the one with him in the window and then looking around the bed and climbing on me. He's so cute. So cute. Don't talk about stuff like what? I'm confused. I didn't say anything bad. I see you. What? I don't know what you're talking about, sweetie. Oh, Ghost Adventures isn't weird. I love that show. I watched it from its inception. All right. I love you guys so much. I really do. But I gotta take Ava potty now and then go to bed. I'm so happy that the internet connection held up. So that's a bonus. Hopefully I won't have any more issues with that. Be safe, be well, sleep sweet, and much love.